Welcome to the ABCs of Bankruptcy and Debt Relief for Real People. I'm Gary Fraley, a California State Bar Certified Bankruptcy Law Specialist. For more than 4 decades, I've helped many thousands of consumers and small businesses solve their financial problems and get back on their feet. I represent clients in Northern California, the Central Valley, and the Bay Area. Can I continue to run my business if I file bankruptcy? That's the most important question most business owners want to know. The answer depends upon 2 issues. First is how the business is organized. The second is what type of bankruptcy is filed. In a Chapter 7 straight bankruptcy, if you have a corporation, limited liability company, or a partnership filing, the company ceases to exist upon filing of the case. If you want to keep a corporation or business other than a sole proprietorship open, you would have to file a Chapter 11 reorganization. For the typical small business, a Chapter 11 reorganization is cost prohibitive, and the success rate is extremely low. A large percentage of small businesses are sole proprietorships. With a sole proprietorship, there's no legal difference between you and the business. You are the business. You are liable for all of the debts, whether they come from the business or your personal debts. A sole proprietorship business could use your own name or doing business as. Example would be John Smith, DBA Smith Plumbing or Midtown Plumbing. It is not a separate legal entity like a corporation is. Because of that, you cannot file a bankruptcy just for the sole proprietorship business. It isn't a separate entity from you. That's the same reason why you can't file a personal Chapter 7 bankruptcy that doesn't involve the business. One way to keep a sole proprietorship business open is by filing a Chapter 13 debt reorganization. There are very strict limitations as to the amount of secured and unsecured debt you can have. If the debt exceeds those limits, you cannot file a Chapter 13 to reorganize your debts. In a Chapter 7 bankruptcy, 11 U.S.C. Section 721 lays out when the Chapter 7 trustee can run a business. The Chapter 7 trustee can't do so without first getting permission from the bankruptcy court. The ability to run a business is then only going to be allowed for a short period of time. Even then, it's only allowed if the business could be sold for more money than if the business was closed. Nowhere in the bankruptcy code does it authorize you, the debtor, to run a business in a Chapter 7 bankruptcy. The United States Trustee's Office has been requiring Chapter 7 trustees to close businesses, except in very limited situations. Besides, the United States Trustee's Office pushing the issue. Chapter 7 bankruptcy trustees do not want you to run a business for their own protection. Chapter 7 bankruptcy trustees have been sued and held liable for injuries caused by businesses they did not shut down as required under bankruptcy law. Because of that liability, trustees are becoming more hard-nosed about shutting down sole proprietorship businesses. This can pose a huge problem if the income you need for your living expenses comes from the business. If what you have is essentially a service business, you may be able to file a motion in the bankruptcy court asking the bankruptcy judge to order the business abandoned back to you and out of the bankruptcy estate. If the business assets have little value and can be exempted, the trustee will often not oppose the motion. Once you get that order, the business is no longer an asset of the bankruptcy estate. That means for the business that it's all yours. Now the trustee cannot be sued for anything that happens after you have regained complete control of the business. Their risk has ended. If there's a real estate sales business, mortgage broker business, insurance business, or multi-level marketing business, the assets of the bankruptcy estate include that business and your downline. That's what the trustee will administer and sell to pay the creditors. This includes funds, commissions on sales where the contract had been signed before the bankruptcy was filed, but the escrow closes after the bankruptcy filing. Other examples would be residuals from insurance sales, payments to you from your downline in multi-level marketing like Mary Kay or Amway. If you have any type of book of business that could be sold to someone who has the right credentials, a Chapter 7 trustee can sell that. If you have something of value the bankruptcy trustee could sell, you may be able to work out a deal to buy the asset back. If you're a business owner, it is absolutely vital that you do not attempt to represent yourself unless you're willing to have the business shut down or possibly even sold. That's akin to doing brain surgery on yourself. Get a professional that knows what they are doing. You have too much to lose. Look for an attorney that is a bankruptcy law specialist in their field in your area. The California State Bar has a list of attorneys they have certified as bankruptcy law specialists. It is broken down by county, so you can find a certified bankruptcy law specialist close to you. I'm Gary Ray Fraley, and I hope this information helps you make an informed decision about your finances.